Okay, so this is the final topic I wanted to talk about. This is about where you're dealing with family members or substitute decision makers who are making decisions on behalf of the resident that you don't think are in their best interests. So these are the types of substitute decision makers we can have, the lawfully recognised ones. So we've got powers of attorney, and they can either be a power of attorney financial or medical. And then there's also a power of attorney of guardian, it's an enduring guardianship, basically. It's similar to a power of attorney. It's where someone sits down while they've still got full mental capacity. They often do it when they make a will and say, I want my son to be my decision maker if I lose capacity. So unlike a general power of attorney, which anyone can have, and you can just revoke it at any time, and if you lose capacity, it will be revoked. So I can appoint my mum, if I go overseas, I could say to my mum, you need to take care of my banking needs, and have a general power of attorney. An enduring power of attorney is designed to apply where someone loses that capacity. And then we've also got VCAT appointed decision makers, and they're guardians and administrators. Guardians deal with lifestyle decisions, but what particular lifestyle decisions they have will depend on what the VCAT appointment says. For example, VCAT may say, we'll give you the right to decide who should visit the person, but we're not going to give you the right to decide where they should live. Though both of those things are things that a guardian could have power to decide, but they won't necessarily. It's very rare that VCAT will appoint someone with all the powers, because they like to use what's called the least restrictive option. So if you've got a scenario where there's disagreement within the family about where someone should live and someone's saying that they should go to residential care, or for example that case I used before with the retirement village, one family member saying go to aged care, the other one saying stay in the retirement village, you might go to VCAT and get them to say, okay, I'm going to appoint someone with the decision to make, with the authority to make a decision about where they should live, but only that. No other powers. So just have a look at the VCAT document, or have a look at the enduring guardian document, and just have a look at what authority that they do have. And with that issue around the restraint, for someone to authorise restraint, that really should be specifically dealt with in that document. I think it would be so rare that it is, but if you're going to rely on that, then it really should be made quite explicit that the person has the authority to authorise restraint.
Would power of attorney medical include that?
No, because they're around medical treatment, so that wouldn't be around restraint decisions, so you really need that enduring guardian for that. Yes. Enduring guardians, guardians and enduring guardians and medical powers of attorney, there's a bit of overlap there, because enduring guardians and guardians have the authority to make decisions around healthcare in some cases, so there can be a bit of overlap. The other thing is the Medical Treatment Act, which is where medical powers of attorney come from, also talks about persons responsible. So if someone has a car accident and goes into hospital, the hospital can rely on this person responsible concept to decide what treatment they give them. So it could just be a son, daughter, it'll be like the oldest sibling, regardless of sex, or a guardian, it could even be. So unfortunately, it's not the clearest thing, but yeah.
So what is there then difference between an enduring power of attorney and an enduring guardian?
Yes, so enduring power of attorney is only the medical or financial. Enduring guardian, it's done in the same way as a power of attorney, but it's a different type of power. So they're the ones making decisions about lifestyle.
Okay, so an enduring power of attorney is either financial or medical.
Mm-hmm.
I always thought that enduring was both, like that was overlapping.
As in the two, financial and medical.
Yeah.
Often people will be both, but they're separate documents.
Okay.
What I was saying before, we're actually getting a change in the law. It'll come in next September. There's going to now just be one power of attorney document, and it will specify what powers they have, whether it's financial. Mm-hmm. There's still going to be a separate one for medical, but the guardian thing will be under that document. So that's probably going to be quite confusing for people to deal with, but the idea is to actually simplify it, because enduring guardians are appointed under, I think it's under the Guardianship Act. Powers of attorney financial are under the Instruments Act, and powers of attorney medical are under the Medical Treatment Act. So we have lots of legislation And then we have guardians under Guardianship and Administration Act and administrators. So much terminology, and then you have to, obviously, all the advanced care stuff is also kind of in this area as well, but we're just talking about decision makers here, but it's a bit of a mess, basically. So they are trying to simplify it all a little bit more, so we're just going to have a Powers of Attorney Act, and that's going to commence next September. It technically commences on 1 January, but most of the operative provisions won't start till next September. And you'll see some new types of forms. We don't know what they'll look like yet, but hopefully it will make things clearer. I suspect there'll be a bit of teething problems, but we'll see.
And will that have any effect on
Existing ones?
Yes, thank you. Yes, on existing.
I'm not sure
New...
that you'll still be able to rely on an existing one. You don't need to go and get a new one. There's a guy that I spoke with yesterday, and he said that he would say anyone with a really old one, pre-2004, should probably be getting it updated. Just because there's some limitations around the ones that were pre-2004. But yeah, they're still valid for their purposes, but if someone's still got capacity, then make a new one. It'll just be simpler, I think. So, and when you make a new one, you automatically revoke the old ones, so there's no need to kind of do two separate things.
Are these national documents or state?
State,
So,
just to make it more confusing.
so New South Wales ones isn't valid in Victoria.
Yeah, there's questions around whether they can be relied on. Another complexity. You can, I think there's actually provision for you to register them so you can use them in other states, but they may not always be accepted by the people you're dealing with. It's not,
Because
yeah,
sometimes
such a
children
mess.
like to live overseas, making decisions about mum and dad. So is an overseas one, what legal basis does that have?
Overseas ones wouldn't probably be recognised in Australia because we don't really know what the situation is around those. So
It's got to be a Victorian basically.
they're definitely the clearest. I don't think you'd be doing anything wrong by relying on a valid New South Wales one.
So if it's one from the United States, I guess.
Yeah, I'd be probably questioning it then. I'd be saying I think you'd need a new one here. I don't really know what the law is there around them or whether they even have that concept as
So
such.
those overseas, would they have to hire a lawyer to go to VCAT and get that sort of...
Yeah, if they still had capacity, they could just sign one in Victoria.
If they have got, you know...
Yeah, then you need to go to VCAT. It's going to really depend whether there's a decision that needs to be made right now. If everything's going along fine, they're living in the aged care facility and there's never been any issues with that, well, you may not actually need one. If you started to want to restrain them, then perhaps you do need them. But yeah, this area is all going to change a bit, so you'll see a change in terminology.
Just one question.
Yeah.
Say residents have dementia, so they can't make a decision if they should be public cared or something at some stage, and they've got several family members like son or daughters. They at some stage they grieve. We got one resident. At some stage they don't agree with each other, go home or stay in nursing home. Then guardian was appointed. And then after that, they agree with he should stay in nursing home. So guardianship was stopped and back to family. They don't need like this decision anymore. But at some stage, this resident gets really sick. She was sent to hospital. Not maybe family will have some disagreement between each other again. And so in this case, what should we do? We should have a, because sometimes you can't go to VCAT, get an answer straight away.
Yep.
So in this case.
Well, one good thing is that once a resident's in hospital, it's a hospital's problem. They can sort out.
If they don't send to hospital, it's like that party said, go send to hospital as soon as possible.
Yep.
In this case, what should we do?
You'd be looking at does the guardian have the decision, the authority to make those decisions?
The guardian already, how to say, it's not there anymore.
Okay, alright,
because,
okay.
Yeah, the accommodation already.
Yep. Yeah, okay, so then we'll be looking at person responsible under the Medical Treatment Act. So there's a whole list.
It's not still when we make phone call, we need to talk to both some separately. But normally don't have something, because this stage nothing going wrong. But some stage I'm pretty sure it will happen.
Yeah, so in other words, you're trying to make a plan for the future and not sure who's decision. You could probably still rely on the person responsible definition because it lists in order who gets a priority. So it will be, if you've got two children, it'll be the oldest one.
Both of them can make decisions.
They may still, but if there's a conflict, you'll go by that list. If they were twins, even then one's older, so you wouldn't go by then. But yeah, there's actually a list of. It's the first of these people. It's quite stepped out, so I think it starts
We don't
with.
have that list at this moment. We don't have any list.
Oh, that's it's in the Medical Treatment Act. Oh, sorry, it's actually in the Guardianship and Administration Act. There is an actual list under the law that says who gets priority of decision making.
I think we don't have that in place.
Yeah, so maybe getting a copy of that. You should be able to get a copy of that fairly easily. Yeah, from the Department of Health website, I'd say they'd have.
Oh,
Victoria. It'll be specific in Victoria, but yeah, having a look around who's a person responsible, and I can send some information through that's been handed out about that list. So that might give you some guidance around that. But best if you can get everyone on the same page. And if there is real disagreement, perhaps going to VCAT.
and it's too late some stage. The treat can be survived, but you don't treat exposed, and then the person will die if you don't send to hospital. At that stage, it's certificate.
Yeah, it is. And I suppose, I mean, the conservative thing is send them to hospital because then a decision can be made. And the hospital can perhaps, we can go to VCAT and get a direction, because VCAT can make a decision about what should happen quite quickly. They do have powers to make emergency sort of decisions. Not quite sure how well they worked. We had one case where we got a call on a Friday and the lady was dying, and there was conflict about what should happen to her, and we called VCAT, sent through an urgent application. They said, we'll deal with it. They didn't, and she died on the weekend. No. So it's not always ideal, unfortunately, but certainly attempting to do that as well will be part of you fulfilling your responsibilities. So it's the right thing to do, to take it up to that level. Take the decision out of your hands. Give it. An Office of the Public Advocate is another resource you could contact in that case and get some help from them. They might even make the application to VCAT. Yeah.
What about in a case whereby you feel like VCAT itself hasn't acted appropriately? I'll give you an example. Like we had a resident who had 2 sons. The older son was living in another state, and the younger one is the one who has lived here in Victoria for many, many years and has always looked after them. Since until the time then the father was not well and he had dementia, but he's a wealthy man. He's got, according to them, he had a lot of money in the bank, he had a huge mansion, and then only at that time, that's when the older son now is chipping in. It was actually more of the daughter-in-law rather than the son himself, So now they are coming in and they want to take dad to go and live with him interstate because they feel he's the older son. And they went through the VCAT, but through knowing them, like when they would visit the nursing home, you could tell they were not the type of people who can look after dad. Like they'll come, they don't say good morning, they say, oh, get out of the bed, can you please change, we are going. This is on many, many occasions. And even the way they would address us as staff as well, they were really, really rude people. So you compare the two with the son who has always looked after dad.
Yeah.
It was...
Did you tell VCAT, were you guys involved in the proceedings?
No.
Yeah, I think putting forward your point, having someone go on to the hearing and just tell VCAT that would certainly, VCAT would want to know that, I think.
Okay.
Yeah. You guys, you're the ones who are seeing it day to day, so you definitely have that. It depends if VCAT happened before you submitted, but I'm thinking it was after.
No, it was after his admission.
Yeah, no, you guys are definitely relevant people, and I would say to contact the Office of Public Advocate because they might be doing an investigation and making a decision. All we can do sometimes, and it really depends on who's sitting at VCAT. They're very different quality of members, unfortunately, and they may not always make the best decision. They're just human as well.
They've already made the decision. He has now gone interstate. Finally, they managed to win and they took him over. So they understand. And it was really hard. It was devastating for us as staff as well. You could feel your heart is breaking because we knew what they were like and we knew what the other son was like to his dad.
Yeah.
So it was really hard, but anyway, the decision was already made.
Yeah, there's always that conflict too because, you know, you might have done everything you legally have to, and really you don't legally have to get involved in that at all. But there's also that you want to make sure he's being cared for the best, and there's an ethical dimension there. But just be aware that sometimes when you get involved in these cases, it ends up being a lot of time and resources. We had one where we went to the Supreme Court on appeal, and that cost our client a huge amount of money, and they were just really an innocent bystander. So that's another dimension to consider. But yeah, it's not an easy thing at all. But I think speaking with the OPA will definitely help, and you can just be effectively like a witness in the proceedings. Go along and VCAT will just say, well, what's your view? And you'll say, well, our observations are X, Y, Z. And getting that even in a witness statement, I think that really helps sometimes. VCAT, the hearings happen quite fast. And you may not get everything you want to across, but if you put it in a witness statement and just give that to the member, you know that they've seen your concerns. And they may just decide, no, I'm not really worried. I think this son will do the right thing. But at least you know you've got the information to them, you've done everything you can, and unfortunately it's not up to you guys. So yeah, it's all you can do, but the law doesn't always get the best result, that's for sure, unfortunately. Okay, so let's have a look at Dorothy, and I think this will kind of bring out some of these issues. Someone want to read Dorothy out?
Dorothy is 91 with severe dementia. She recently had a stroke and has been prescribed a diet of thickened fluids. Dorothy's daughter Meredith is her power of attorney medical and her enduring guardian. Her son Matthew is her power of attorney financial and manages her finances. Matthew and Meredith do not get on very well. Meredith visits her mother frequently and seems to get on with her very well. Matthew rarely visits. Before coming to Waterloo Aged Care, Dorothy used to live an alternative lifestyle in a commune in rural New South Wales. She moved down to Melbourne later in life to be closer to her family. Like her mother, Meredith has an alternative lifestyle. She is an animal activist. Lately, Meredith has expressed a wish that her mother only be given raw vegan foods. The nutritionist has advised against this due to the limitations in the types of food that Dorothy will receive given she's on a diet of thickened fluids. Meredith has been told about this, however she insists this is what her mother would have wanted. Lately, Dorothy has started to suffer from malnutrition. The nutritionist and nursing care staff are concerned for Dorothy's well-being. On one of his rare visits, Matthew sees his mother eating different food to the other residents. He queries why this is the case, and when staff tell him that this is what they have been told to give Dorothy, he becomes angry with staff and accuses them of not looking after his mother.
So yeah, what do you guys think of the issues here, and what should Board of You do? Have they done anything wrong, do you think?
They should step up, say it's not the right decision for her to have this kind of food. And even she's having power of attorney for her medical power, but if her decision is not suitable, then we could say something and even go to VCAT and take her power away.
Yeah. I think it is relevant though that Dorothy herself may have wanted this. If she still, because she had that alternative lifestyle and possibly was, vegan in that case, and let's just say she was. So just because something's not what you would say is the best thing for Dorothy, if the VCAT would still look at, what would Dorothy have wanted, and I think the fact that she's had that history is, evidence that that is something Dorothy would have wanted. Might be a different situation if Dorothy, was not alternative and there was no evidence she ever wanted to be vegan and she ate, roast and pre-veg every Sunday. And then you've just got Meredith sort of imposing her personal views over her mum. But I think there is that, one of the things that a guardian, and Meredith is her guardian here, has to look at is what would her mother have wanted. And if her mother said to her, I want to be vegan and eat raw foods, or, eat a very low carbon diet, then perhaps perhaps that's something that will be taken into account.
So she sort of, it was from the start, since lately, married.
Mm.
So it's not really initially, so she's changed her mind. Or,
Yeah,
So
and I think
therefore, wouldn't that be in the documents documented from the beginning?
yes.
yes, yeah, exactly, and that might be a reason why you would be more concerned here. Yeah, so I think it's but I suppose what the point I'm trying to draw out here is that just because something is not objectively in someone's best interests doesn't mean it's not the right thing for them.
And would it be legal then, all right, if the Meredith signs a waiver? Because if a nutritionist tells that she has to be on thickened fluids and obviously then also a soft diet for swallowing purposes, then legally she would have to sign something.
We used to document, family infused, or urine concurrent infused this treatment.
Yep.
Yeah.
We had a situation where a gentleman who's had a bad stroke and is on, vitalised food because that's what he can swallow, but he doesn't want to eat it.
Mm.
His wife actually signed a waiver to say that he should be allowed to eat whatever he wants.
Yep, that's a common one that comes up.
And the doctor had to agree
Yeah.
as well.
That's why people say that you don't refuse to protect us, or you just document family infused checkers or whatever.
Usually, get a signature from the family to decide that they are aware of the risk as well.
Yes,
Yes,
definitely.
it's like bed holes, things like that. Yeah.
Because what you're wanting to show there is that they have made an informed decision, and informed decision means they have to know about the risks. So provided you've told them about the risks,
Yes.
then So good. So I think that definitely getting as much in writing, getting them to sign to show that they understand is what you want to do there, and that's really that sort of informed consent issue. But I think the fact that you now have, what's his name, Matthew, objecting to it, that's another reason why it might be best to go and get someone else to look into the situation, like VCAT, the Office of the
But
Public
for
Advocate.
this, if Matthew would do something because he believes staff didn't, tell Meredith beside what she said, give to Dorothy, if we suggest something like some kind of supplement, and also suggest her to buy some food, bring some food in, which should be add a variety for Dorothy, and then if he would do this.
Yeah, and I think, there might be other alternatives to look at. Maybe rushing off to VCAT isn't the first thing, the right thing to do. I suppose it depends how long the situation continues and what else you've tried to do to make sure that Dorothy is getting that nutrition. But it's a tricky one because you're balancing up that, what is it Dorothy would have wanted. We can't really find out exactly now what it is she wants. It's different if someone's got full capacity and they say, I don't want to eat thickened fluids, I'll take the risk, thank you. And a case where, we've got two people saying different things and one of them's got the power, but one of the things about being someone's guardian or power of attorney is you do have an obligation to act in their best interests. That also means taking into account their wishes and their preferences, but you do have to, one of your responsibilities is to act in their best interests, and that's sort of what I've covered here. So as I said, you have to give effect to their wishes, and so that could be what Meredith's saying she's doing here. And fiduciary obligation, so as a power of attorney you've got a fiduciary obligation, just basically imposes a much higher obligation to make sure you're doing the right thing and not having conflict of interest with them. Okay, so now Dorothy again. So now Matthew's causing some trouble. So he makes a complaint to the aged care complaint scheme, and unfortunately since that time he stopped paying fees, and he says he doesn't have to pay the fees while the complaint's being investigated because you're not looking after his mother properly like you've agreed. Fees are now $10,000 in arrears. So what do we do here?
So you can say that they're following the wishes of the guardian. There's a legal point of view, and he has a legal right to pay bills.
Yes. Yep. I mean, not only a legal right, it's a legal obligation. Yep.
To pay her accounts because that's his job.
Yep. Exactly. And if he's acting in her best interest, he'll pay her bills. And one of the main reasons we say that is because security of tenure also enables you to ask someone to leave if they don't pay their bills. So he's exposing his mother to being asked to leave because he's not doing his job. So therefore he's not acting in her best interests.
Yeah, so it's actually with care under his role.
And so the one solution here, very few providers will ever ask the resident to leave, so asking Dorothy to leave is not a very nice thing, and suing Dorothy would not be very nice either, and unfortunately you can't sue the son, you sue Dorothy. So it's not going to be great PR, facility takes 88-year-olds to court for 10 grand. So
You can apply for an administrator to take over.
yeah, that's exactly it. We've had a situation like this lately though, and VCAT have decided that they'll instead order the attorney at the very last minute, after 3 years of not paying fees, being behind ridiculous amounts, they've decided they'll accept that he will pay $3 grand a month from now on. I personally don't think it's going to last very long, but VCAT they emphasise that they have to use the least restrictive option. So where someone's given their son the power of attorney, they'll say, well, that's what this person would have wanted, therefore we won't take that away very easily. So let's give this scenario a go. It's just an awful situation for providers because it's so quite costly. Going to VCAT costs you money, you can't get costs off the other person except in very rare cases. But sometimes it's probably the lesser of, it's either that, kick the person out or sue them. And I would say around the monetary point as well, with the changes to the Aged Care Act, I'm sure you're all aware that there's sort of more exposure for providers now with bad debts because of bigger means tested care fees, also the greater choice around how people pay their accommodation payments. So we're really emphasising for people to get onto it early. Don't let it get to $20,000, $30,000, $40,000. Have a limit, set in place a policy and have a limit of where you take action and what it is that you do. Letters of demand, debt collectors or whatever, but get onto it early because it's not fun trying to get your money back and it's quite expensive. So that was pretty much everything I wanted to cover, but I just thought, is there anything anyone feels I haven't covered in enough detail or anything I haven't covered at all? Are there any other scenarios that come up for you that you feel?
Oh, car licence, you got a vessel, not demented, you couldn't, but you've got some medical conditions and they have poor eyesight and short-term memory, but they're still driving. But they're resting in our facility. What's our responsibility in that case? You have concerns about their drivability.
Yeah, so I think that brings us back to our first scenario where we've got someone who goes and causes a car accident, say. You don't have an obligation to protect all the other road users from that person. And if they've got capacity to make a decision to take that risk, it's really their decision.
Would you talk to the GP to say, get reviewed maybe by the TAC? Or?
Yeah, look, I think speaking to the GP, speaking to the family, definitely wise things to do.
Say he kills one of the residents backing out of the facility, then?
Yeah. Well, if you've done those things though and you've said, well, this person's been assessed as safe to drive by his GP, and I think it would be important to get that assessment done and have, just so you're not, nothing's been done about that effectively. But I think if you've done that, well, you've acted reasonably because you don't have the right to say, I'm taking the keys off you. You're not allowed to do that. So therefore, no one can say you breached your duty of care because you've done everything you can. So yeah, it's always just what can we do to manage the situation? What steps can we put? Let's just make sure he is okay to drive. And if someone else makes that call, similar to, say we go down to VCAT and they say, no, Meredith gets to make that decision, well, you've done everything you can. If she dies because she chokes, well, no one can say you didn't do what you were obliged to do, so, yeah. Were there any other scenarios?
So really in that case, just documenting from our side, would that be enough? Or do we need like a signed document, like a waiver?
Look, waivers are typically used where people are undergoing, say they want to go bungee jumping, so they'll sign a waiver. So it's really to say, it's really an acknowledgement that you're making an informed decision about the risks.
That that activity, whatever you're doing, is dangerous and that you appreciate it.
Yeah. But in effect, all it is evidence that the family member knew about the risks and that they accepted them. So it doesn't really have any more effect than say a tape recording of a conversation where the risks are all explained, the family member says, yes, I understand, and I take those risks. So a waiver is really just about proving that you've got informed consent. Yeah. And the thing is, people do sue aged care providers. I'm not going to say they don't, but there are absolutely no cases in court about it. And I'll tell you why. It's because aged care residents, this sounds horrible, but when it comes to the law of negligence, their lives are not considered. You won't get a lot of money because they are elderly and they're not working. They don't have income capacity, income earning potential. It's not going to be. You're not going to get them a few $1 million for someone.
Conversation's not worth it.
Exactly. So what tends to happen is that these cases will be settled, but just for a little bit of, maybe, I don't know, $30,000, $50,000 or something like that, because it's cheaper than going to court. But no one will actually take it all. Well, be unlikely they'll take it all the way. So in America, we have cases where you get these huge punitive damages awards, although they have written that in. So even if the person's life in economic terms wasn't worth a lot, they can still whack the company with a $300 million fine, effectively. But we don't have that in Australia. So there's not that incentive to sue for families to spend all that money if they only end up with, $40,000 in their pocket. So it's a bit of a sad thing, but that's how the law of negligence works and how it values. Yeah, whereas if say a young superstar footballer gets injured, his earning capacity's gone, his life will, that he'll get a bigger award of damages. So we really don't see many cases that actually go to court. Well, there are absolutely no cases where an aged care facility has gone to court on a negligence case. Obviously, coronial decisions, that's different. But and you don't want to just be saying, oh, well, no one's going to sue me, therefore I'm not going to do the right thing, because there's so many other consequences that flow if you don't take those reasonable steps. And that's, sanctions and also coronials. So they've definitely been doing the right thing. But yeah, waivers are typically used to prevent someone from suing. So yeah. Any other?
What about in a case where you have a resident who has got some medical issues, and those medical issues need to be sort of investigated further? Let's say the GP recommends that they would rather have that resident investigated further outside the facility itself. So that means that the family has to pay, or the resident, there are some payments that the resident will need to do. But then we find there's a power of attorney, and the power of attorney is not agreeing to those procedures being done. So at the end of the day, the resident continues to suffer because the facility, you can't pay for it. It should be money coming from the residents, which should be coming from the power of attorney. Or how do you deal with such a scenario? That's a
really good example, and that would be a situation where the power of attorney is not acting in their best interests. So provided the resident has enough money themselves to pay for that, I don't think the law would require the power of attorney to go and spend their own money, but you would say that, well, the resident should be able to afford these things.
Yes, in that case, the resident is able to, because it's someone who has worked and they do have money sitting somewhere. And they have got the capacity to pay, but the power of attorney is the one who is a bit slack about any suggestions. Sort of, they say, oh, what will it benefit? But it will benefit the resident. Horrible, isn't it? And it's not like someone who is dying, someone who still has got a potential of life, if things are done the proper way.
Definitely documenting all of that, documenting your concerns, your discussions with the power of attorney, and then ultimately go to VCAT or the Office of Public Advocate. Probably contact the Office of Public at first. If they don't take any action, then you go to VCAT and say, we're concerned that this person's just not making decisions in the best interests of this resident. And here's our evidence for it, that the doctors recommended this, and then it's up to VCAT to determine. Yeah, so to really bring it always back, considering, are they acting in the best interest? That's always your question with these decision makers.